in this
We
matter?
have 4. Let me
4.
see if anyone
Sorry.
else has jumped on.
Camille's in. I just saw her.
Oh, okay. Thank you, Sal. Yeah, just board
Yes,
members,
Yes.
good morning, everyone.
speak right up.
I'm on here.
Okay,
That's
that's
I'm on
5.
here.
So 5 we have now, which makes our quorum is 5.
Testing
Yes.
1, 2, 3.
Okay, and let me just take this thing that's in the way on my computer because it's distracting. Okay, just me. All right, very good. All right, so we will start. Thank you all for your patience this morning. Appreciate it. All right, so this is the regular meeting of the Board of Examiners for Nursing today, June 3rd, 2026. I am Gina Reiners. I am the chair. I am an RN member, but I am also an APRN. And what I'm going to do first is have the board members introduce themselves. So if you can unmute yourself and introduce yourself, that would be great. And I'll just call out your name. So Cindy.
Good morning, Cindy Arpin. I'm an RN member and a nurse educator.
Okay, thank you so much, Cindy. Sal.
Good morning, everyone. I'm Sal Diaz. I'm an RN member and nurse educator.
Okay, thank you, Sal. Mary is not here today. Camille.
Hi, good morning, everyone. Dr. Camille Payne. I'm an APRN member.
Okay, thank you, Camille. Elizabeth is also not here today. Lisa.
Good morning. I'm Lisa Freeman, and I am a public member.
Okay, thank you, Lisa. Let's see. And Diane. Is Diane on? Board member Diane. Okay, just checking. All right. Brett, you can always let me know if Diane pops on. All right, so my understanding is that we do have a quorum and we will continue. I will ask if anyone in DPH who would like to introduce themselves, please do that. Unmute yourself and introduce yourself at this point.
Good morning, Liz Bannon, Deputy Legal Director, DPH.
Okay, good morning, Attorney Bannon.
I was complaining superintendent. I throw a big stink about that.
Yeah.
That's bullshit. Freaking kids dropping.
Excuse me, please, excuse me.
And that's not even like.
Please mute yourself, or Brett, mute everybody. Okay, thank you. Just be mindful, everyone in the audience, that you need to mute yourself unless you're speaking. We appreciate that and want to respect that for everyone on today. Okay, all right, thank you. All right, anyone else for DPH that would like to introduce themselves?
Good morning, Dana Dalton, Department of Public Health.
Okay, good morning, Dana.
Good morning.
Good morning.
Sorry. I'm sorry. Helen Smith, Department of Public Health.
Good morning, Helen.
Sue Camerata, Department of Public Health.
Good morning, Sue.
Good morning.
Good morning, Brett Karpuska, Department of Public Health.
Good morning, Brett.
Good morning, Ina Ehrlich, Department of Public Health.
I think I heard Ina. It was I couldn't hear too well, but good morning, Ina. Anyone else that would like to introduce themselves before we begin? From DPH, Department of Public Health.
Good morning, Louis Maldonado, Department of Public Health Practitioner Licensing.
Good morning, Louis. Thank you. Okay. Don't want to cut anybody off. Okay, so I think we're good at this point. All right. So we will go to our agenda. We do have a packed agenda this morning. And the first thing on our agenda is the approval of the minutes. So I would ask if I could have a motion from a board member on the minutes for May 20th, 2026, our regular meeting.
This is Cindy Arpin. I'll make a motion to approve the minutes from the May 20th, 2026 regular meeting.
Okay, may I have a second, please?
Second,
This is
Lisa.
Camille, second.
I think that was Lisa, I believe.
Yeah.
Yes, okay, good.
Yes.
Okay, thank you. Thank you. All right, so we have a first and second discussion, questions, additions, deletions, concerns on these minutes. I do have them right in front of me from board members. Okay, again, I don't want to rush anybody. But hearing none, I will now take a roll call on that. All right, so Cindy,
Aye.
Sal,
Aye.
Camille,
Aye.
let's see, Lisa,
Aye.
and I, Gina Reiner, say aye. So these minutes have passed as presented to us. All right, so we will move on. Second item on our agenda is the 2026 legislative session overview by Kimberly Sandor, who is the Executive Director of Connecticut Nurses Association. And we welcome her. And Kim, if you could give us a brief update, we would appreciate that.
You bet. Good morning,
Okay.
everybody. Nice to see you all. Can you hear me?
Yes, we can.
Perfect. Can I just go ahead and share my screen because it's kind of easier if you half read and half listen. That works.
Yeah.
Just know that when I do this, I can't see the chat, so please just jump in. So this is just a quick legislative wrap up. As you know, the Connecticut Nurses Association is a membership association that advances nursing practice, protects patient safety, and advocates for a strong healthcare workforce. So during the 2026 session, that's what we did. We worked with our nurses, legislators, coalitions, partners, and state agencies. And I have to say it was quite a session and really appreciate all of our nurses across the state who supported us, as well as our public health committee. And there was over 7 committees that we testified and worked with this session, as well as our colleagues at DPH, who that partnership was really integral and important for the work moving forward. We do our work through Nurses Belong. They contribute and lead in these different ways as we do our work through advocacy, professional development, and leadership. And as we go through this session, we do work before the session, but then during the session, we do bills, hearings, we work with everybody and alongside legislators to get things done. So while I'm presenting this as a wrap up for the Connecticut Nurses Association, we just want to acknowledge all the hard work of our nursing members and partners in really getting this work done. I think it's important for nurses and the board to realize all the people that participate in moving legislation forward, because as your job is to hear and understand nursing at this highest level with the breadth and depth of our profession, that's our important work we do at the state, is really holding the nursing profession and the work of nurses front and center. And in order to do that well, we really need input and feedback from a lot of nurses, and just want to celebrate that. We did have a number of wins this legislative session, so you got us high-fiving out there. Workplace safety and violence, we got passed a bill on workers' comp that if you're out for a injury sustained while on the job at work related to workplace violence, the workers' comp only covers so much of your salary, but this would make you financially whole, as well as not require you to take PTO and other sick days to care for yourself, which is a really big win. As you know, workplace violence continues to be a driver away from the bedside and an issue for nurses in nurse retention and feeling safe and being able to do their work. With the speed of work, the acuity of care, and the difficulties people are facing with the healthcare system, people are entering the healthcare system at a much more heightened space and often very, very sick. And the environment in some of these spaces can be challenging, and that's all felt by our nurses. So this is it's a very nurse oriented law that went forward to really help the nurse. We're also creating a work group that's going to flag charts of to discuss strategies to flag charts on patients who have committed violence in the workplace environment before towards a healthcare provider. A number of hospitals are already doing something similar to this, and we're looking at how can we ensure communication between health systems by looking at our Connie Health Information Exchange, which is like the big umbrella in the state. How can we do that in a way that's consistent and fair and doesn't have bias, but also informs nurses, just like fall risk, that people have had an episode of violence in the past. We know violence can be from a medication or pain and all these other things that are contextual, but it's just another piece of information to allow providers to be safe. So we hope to launch launch of that work group this summer, and we hope to see legislation next year. There's also a bill strengthening oversight of the hospital staffing. So not only does it look at hospital-wide meeting that safe staffing ratios set by the nursing staffing plan, but it looks at unit by unit, and the DPH is going to be collecting and reporting that information. So it's really drilling down a little bit more to look at accountability of those staffing plans and those ratios that are established by 51% nursing bedside nurses staff. So really important component there. And the graduate loans, I mean, you've all heard about this. It was the HR 1, a federal bill that removed nursing as a graduate degree and, or excuse me, as a professional degree, and caps our access to lifetime access to loans. And Connecticut really hit this one out of the park and created funding for a graduate loan assistance for healthcare professionals. And I think this is one of a kind across the country right now, really leading the way, but understanding that, yes, education is super expensive, but not giving people access to loans is an immediate, because it starts July 1st, right? The federal rule starts July 1st. That gives no times for schools to make any sort of an adjustment, but Connecticut really stepped up in that space. You've probably heard about the federal lawsuits going on, including Connecticut Attorney General is trying to address that, as well as the American Nurses Association. We also did some things where sometimes a win is that you reshape something and it didn't happen. And we are looking at the unlicensed personnel administering medications. And this comes up time to time in different settings. And unfortunately, it's not something that's done with a big group thinking about how can we get something done and what problem are we trying to solve. It kind of just gets thrown out there and we all have to react to it. So this was another piece coming out this year that we had to do a lot of education on what is medication administration. And when we're doing it for folks that can't do it for themselves, what does that look like and what can be done safely? So that bill did die this year, but we know that this is Connecticut's one of the few states that still doesn't have unlicensed personnel giving medications in certain settings. And we're going to be, the Connecticut Nurses Association will be launching a task force to look at this and look at the different settings that this is happening in. With the Rural Transformation Grant, this is going to be a big issue that we as an association understand and can influence and shape the way things are moving forward. Medication administration is a nursing thing, so we hope to be part of that as it moves forward. The last win, as I say, changes we influence, was around the Board of Examiners of Nursing. You guys, 2 bills came out, kind of, whoa, what happened here? Where did these things come from? Kind of bills. It wasn't something we had put out, but it really, there was 2 things. One was the consent, which we had talked here about a couple months ago, where it would kind of go by the board and just a nurse would enter a consent order without coming through the board. They could just do it with a commissioner, and that went away. And the other one was about thinking about education, educational programming and pass rates and things like that. And that went away too. But the reality is what this has done for the association is really highlighted the need to create kind of a brain trust, a white paper that we have, that we can follow what's going on with the Board of Examiners of Nursing across the country, really understand the NCSBN quality indicators that are coming out, what are the school benchmarks and things like that, as well as some of the oversight and things that are happening across the country. So because those things came out, it really highlighted a gap. We really worked with a lot of people to bring ourselves up to speed to be able to contribute meaningful in those discussions up at the General Assembly. But we're going to create a work group, and we invite any of our members to come and join that work group. We know that the school nursing regulations are somewhere in the process out there. We know that NCSBN indicators are coming out. We know this is really important for all of our nurses in light of the Nightingale things that have happening. So that work group's coming based on the fact that those bills came out this year, and it really pushed the issue that this is something we need to be prepared for. So that's all I'm going to say for now. We have lots of stuff looking ahead in addition to that, but that's work to come and work we'll continue to do. And again, invite our members or folks to join us to be part of that work.
Thank you so much, Kim.
You
Really
bet.
appreciate it. And does anybody have any questions for Kim on anything that she discussed? Make sure I can see it and just raise your hand or what have you if anyone has a question for Kim.
This is Cindy. I just want to say thank you, Kim, for bringing this information to us and for advocating for nurses so strongly.
Yeah.
Thank you, Cindy, and thanks all of you for your help and input. Again, we don't do it alone.
And I think Lisa, you have your hand raised.
Yeah, thank you. Kim, I just have one question. I'm a non-nurse,
Yes.
except in spirit. And I was just wondering, as you talk about the authority of the board and consent orders and things like that, a lot of times our input does have to do with protection of patients. And if it's pulled away in your work group, will you at least have representation from patients so that we can make sure that they are protected? Because I think consent orders are very important, and that is one area where at times we do find things we want to inject.
Lisa, thank you so much for bringing that up. And I love that you're here as a nurse in spirit. It's so important because nursing isn't just about nurses. It's about all the folks that we care for, that may be a patient or a family member, a community, etc. To be clear, the consent order thing bypassing the board did not pass. That went away.
No, I
Thankfully,
gathered that.
yeah, our Department of Public Health colleagues were wonderful in hearing our concerns about that. And it is not something that we as an association want to ever see happen. And we will continue to advocate for the role of the board and the importance of the board. So that we wouldn't have that. The task force is really meant to look at what are the things that are happening that need to be shaped and looked at again, right? The healthcare system has changed, the landscape has changed, the places where practice is happening have changed dramatically. The transition to practice, we have 44% of nurses going to a hospital. That's way different than when I got out. I'm not going to tell you what year, but that year that I came out, most nurses went to a hospital for their initial training. So what does that look like now that less than half are getting that initial training somewhere else? And what does that mean for a nurse taking care of a patient? Right? And what does that look like? And what are the challenges in that space? And how can we help them? Because in the end, we don't want anyone coming in front of you, right? We want people to understand that scope. But if nurses are being employed by people and their employer is setting up their practice, our nurses need to know their Nurse Practice Act, their boundaries, what they can and can't do, and not just what an employer may be telling them to do. We see this in aesthetics a lot. It comes up and people have a lot of questions about what we can do. And that ultimately is protecting our patients. So patients are front and center. Actually, my parents live with me, and I learn every day about how hard it is to be a patient and to be receiving care. So I hold you very close, Lisa, and you're welcome to join.
Okay, thank you.
You bet.
Okay, so thank you very much, Kim. We really appreciate you coming and presenting, and sounds like a lot of good work with everybody, all these people that have been involved. So thank you again. This is great because we really the board really wants to know what's going on and what's happening and changes and so forth. So thank you. Thank you again. All right, we'll see you again in the future.
Gina,
Thanks for
this is
having me.
Sal.
Oh, I'm
See you
sorry,
in
Sal,
South
go right ahead.
I
Go
had
right
my
ahead,
hand
Sal.
up. Sorry. Again, I want to repeat like what Cindy said. Kim, thank you so much for all your hard work and dedication to nursing. And Lisa, thank you so much for your dedication as a public member. You do you contribute so much to our board. And Kim, I think that was a great idea to have her join because she has a lot of good information to share with us to protect our patients. So thank you.
Absolutely. Thank you. And thanks for having me.
Okay, thank you. All right, so we will move on to our next agenda item, which is some motions for summary suspension. We have two of them on here. We will take the first one, which is Bethany J. Robinson, RN, petition number 2026-723. Attorney Nanny is on the case for DPH. First off is Bethany J. Robinson in the audience. And if you are, unmute yourself and introduce yourself, please. Bethany
I'm here.
Robinson.
My name is Bethany Robinson.
Okay, and if you can leave your video on, it would be really helpful. So I sort of know where you are because I have a lot of boxes in front of me. Matter of fact, this is now 49 boxes I'm looking at. All right, so I appreciate that. Thank you for introducing yourself, Bethany. Bethany, do you have an attorney representing you?
I do not.
Okay, all right. Attorney Nanny, are you here?
Yes, good morning. Anthony Nanny for the department.
Okay, thank you so much. All righty, so all the board members would have received this information in their secure package on the secure website.
Okay, thank you.
Okay, if everyone can mute themselves, that'd be great, unless you're speaking, and not Attorney Nanny. Hang on there, Attorney Nanny. Okay, Attorney Nanny, can you present this to the board?
Of course, this is the matter of Bethany J. Robinson, petition number 2026-723. Respondent is licensed to practice as a registered nurse by the department. She has a disciplinary history. She surrendered her license in petition number 2022-540. Her license was reinstated by a reinstatement consent order in petition number 2023-766, which was based on a mental illness or emotional disorder that impacted her practice as a nurse. The department received a report from her employer on April 30th, 2026, which was a requirement of her probation. The letter stated that her employer was uncertain if she could practice safely. Respondent underwent a fitness for duty evaluation, and the evaluator opined that respondent was unfit for duty. Respondent also has a physical illness or loss of motor skill that does or may affect her practice as a nurse. As such, the department is requesting that this Board of Examiners for Nursing summarily suspend her license to practice as she represents a clear and immediate danger to the public. Thank you.
Okay, thank you, Attorney Nanny, for that presentation to the board. May I have a motion from a board member?
This is Cindy Arpin. I move to grant the department's motion for summary suspension for Bethany J. Robinson, RN, petition number 2026-723, as the respondent represents a clear and immediate danger to the public health and safety if allowed to continue the practice of nursing.
Okay,
This is
thank
Sal.
you.
I'll second.
Okay, thank you, Sal. We have a first and a second. Discussion, open for discussion only for board members. Any discussion, comments, questions, concerns? Okay. Don't want to rush anybody. Hearing none, I will take a roll call. Bear with me. Cindy Arpin.
Aye.
Sal Diaz.
Aye.
All righty. Camille Payne.
Aye.
Oh, okay, thank you. Lisa Freeman.
Aye.
And I, Gina Reiner, say aye. All right.
Gina, just so you know, Diane's here.
Oh, Diane's here. My apologies. Okay, okay, thank you. Thank you, Sal. I did not know that. Diane?
Aye.
Okay, I heard you. I heard aye. Okay. All right, then I said aye, Gina Reiner, say aye. All right. So this has passed, all right, this suspension. And so let me get your name. Ms. Robinson, what will happen now is that your license has been suspended, and at this point in time, it'll go to a hearing, okay? DPH and the hearing office will take care of all of the information with regard to that, and we'll get in touch with you. Just want to make sure you're aware of that.
Okay, thank you.
You're welcome. All right, so we will move on to our second. So bear with me for one moment. Motion for summary suspension on Maria Carmel. Okay. Edgar de Valmar, I believe, RN, petition number 2025-602. Is Ms. Maria Carmel Edgar de Valmar, I'm not sure I'm pronouncing that correctly, in the audience? Is Maria Carmel in the audience? And if I'm not seeing it and any of the board members see that someone's raising their hand, please alert me, because I only see so many of the little boxes, so to speak. Okay, I'm not hearing any when responding. So is there an attorney for Maria Carmel Eduvalmar in the audience? Okay, I'm not hearing that. So Attorney Nanny, you want to present this to the board?
Yes, thank you, Madam Chair. This is the matter of Marie Carmel Edouard Valmier, RN, petition number 2025-602. This matter was referred to the department as part of the FBI and Department of Health and Human Services investigation Operation Nightingale. Respondent attended Ideal Professional Institute in Miami between June 2018 and August 2019. The department received an affidavit from Ideal's owner and operator that indicated anyone residing outside of Florida while attending the school did not complete the required coursework and clinical training to earn an Associate of Science in Nursing. Respondent did live in Florida, but she moved prior to starting at Ideal according to a Nexus search. The investigation also uncovered other inconsistencies, such as the fact that the total number of credits and courses on the transcript are not consistent with the courses listed in the approved program outline. Also, the total number of credit hours that the transcript reports respondent earned is not consistent with the actual credit hours listed on the transcript. Based on this information, the department believes that respondent's continued practice as a nurse presents a clear and immediate danger to public health and safety and is asking the board to summarily suspend her license to practice nursing. Thank you.
Okay, thank you so much, Attorney Nanny, for that presentation. Okay, may I have a motion from a board member with regard to this summary suspension?
This is Cindy Arpin. I move to grant the department's motion for summary suspension for Maria Carmel Edouard Valmer, RN, petition number 2025-602, as the respondent represents a clear and immediate danger to the public health and safety if allowed to continue the practice of nursing.
Okay, may I have a second?
Diane. This is Camille. Okay.
Okay, I heard both Diane first and then Camille. So if one of you could go ahead, that'd be great. And that's great that you are contributing.
Diane.
Diane, second, great, thank you. All right. All right, so we have a first and second on that. Open for discussion, questions, comments, concerns, discussion of any sort. Okay. Let's take a second. Not hearing any. I will now do a roll call. Okay. Bear with me for 1 second. I'll get my roll call sheet. All right, Cindy?
Aye.
Sal?
Aye.
Okay. Let's see, Camille?
Aye.
No, Lisa?
Aye.
Okay. Diane?
Aye.
And I, Gina Reiner, say aye. All right, so this has also passed. The summary suspension has passed. Okay, we will now move on to the next item on the agenda, which is a reconsideration of consent order. Christina M. Martinez, APRN, petition number 2024-317. And just for a moment here, I know that Attorney Newton is on this case for DPH. My understanding is that the respondent's counsel could not attend the last board meeting due to personal reasons. The board denied the consent order at that meeting. Respondent's counsel has requested an opportunity to be heard prior to the board's reconsideration of that matter. That was the information I was given. So is attorney, and bear with me if I'm mispronouncing this, Frank J. Szilagyi in the audience? Attorney Frank J. Szilagyi. Are you in the audience? And if so, please unmute yourself. I think I see someone waving. Bear with me.
Are you able to hear me?
Now I can hear you. I wasn't hearing you prior. Okay.
Thank you.
You're welcome. You're welcome.
Good morning, Madam Chair.
Good morning. So hang on 1 second. I just want to get to, and I'll let you speak. Attorney Newton. I just want to make sure she is here and present because again, I have a lot of different little boxes in front of me. Attorney Newton, would you just introduce yourself?
Good morning, Attorney Joelle Newton for the department.
Okay, thank you so much. I'll just make sure you were there. All right, so we did have this consent order. Again, the Respondents Council, which is the attorney who just introduced himself, could not attend the last board meeting. I just want to make sure the board members understand this due to some personal reasons. And the board denied the consent order at that meeting. So that, okay. The Respondents Council has requested opportunity to be heard prior to the board's reconsideration of the matter. So we are going to, before we do anything, Attorney Newton, you have your hand raised. Go ahead.
Yeah, I was going to say, would you like me to go over the facts of the consent order prior to hearing
Yes,
from?
yes, definitely. I was just going to turn to you to do that. I was going to just try to set it up again of what's happening. So there's no confusion, but go right ahead, Attorney Newton, do that. Present to us the case, so to speak, and then we'll let the respondent's attorney speak.
Thank you. Good morning, Joelle Newton for the department. This concerns respondent who is an APRN who injected some dermal filters. The standard of care violations are: one, she did provide informed consent prior to the procedure, but she didn't disclose all of the risks, including the vascular occlusion or nerve compression or filler migration. So the informed consent was done, but it was not complete. And she also didn't document an expiration date on some of the medications, and there is no documentation of a physical assessment. She also dispensed prednisone and didn't document the prednisone in the record. So most of this consists of documentation issues and not having a full informed consent. The consent order that you have in front of you includes a reprimand and also requires coursework in record keeping and documentation practice. The board in prescribing practices as well as, documentation. The board looked this over prior and has also suggested a civil penalty. Just to let the board know, the respondent no longer practices in this type of practice or with this specific company. She was not self-employed. She was working for somebody else, and she now works for somebody else. At this point, I will turn it over to Respondents Council.
Thank you. Thank you, Attorney Newton. Good morning, Madam Chair. Good morning, members of the board. I appreciate the opportunity this morning to address the board on this important matter for Christina Martinez. So I'd like to, if you would indulge me, just give you a little bit of background about who Christina Martinez is and the kind of work experience that she has. So in 2000, Christina graduated from Quinnipiac University with a BS in nursing. She was licensed as a registered nurse.
Or press star to contact the operator.
Okay, excuse me, I'm sorry to interrupt, attorney. Everyone, please mute yourself so that only those that are the person that is speaking, okay? Thank you so much. Go ahead, attorney.
Thank you for that, Madam Chair. So as I was saying, after graduating from Quinnipiac University, Christina was licensed as a registered nurse and began her career in the hospital setting, working as a staff nurse on the cardiac floor at Hartford Hospital from 2000 to 2004, and then from 2003 to 2012 at St. Francis Hospital. At St. Francis from 03 to 08, Christina was a staff nurse, again, working on the cardiac floor, providing direct patient care. She transitioned to an administrative role as a nurse manager in 2011. In 2011, she returned to Quinnipiac University for further education, pursuing a doctorate in nursing degree, which she was awarded and which she earned in 2014. In 2014, she became licensed as an APRN. From 2014 to 2018, she returned to private practice and worked in a primary care setting at Sterling Partners and at Pro Health, primarily providing cardiac treatment and services to patients. In 2018, she also worked for a cardiologist providing consultations for that cardiologist at nursing homes. And then, as we know, in 2020, COVID struck, and Christina continued to work in a primary care office in Windsor and at an urgent care office in West Hartford. In the fall of 2021, Christina enrolled in an intensive small setting program in Portland, Oregon, to be certified to provide multiple services in the cosmetics/aesthetics medical practice. And she successfully completed that and was certified to do so. And so later in the fall of 2021, Christina was employed in Glastonbury at a practice known as Blush Med Spa. Christina had no ownership interest. She was not a partner. She was a W-2 salaried employee working part-time there while she continued to work in a private setting in the primary care area. Regrettably, in 2002, her husband passed away, and Christina is a widow with one high school-aged daughter. So in 2023, Christina was working just one shift at Blush Med Spa and returned to the primary care setting that was more aligned with her interest in more aligned with her interest in direct patient care in the primary care setting and more aligned with primary care medicine. She's no longer employed by Blush Med Spa. For most of her career, Christina has worked 2 jobs in order to make ends meet for her family. As Attorney Newton outlined, I guess let me give you a little background. So the genesis of this complaint was parallel to a civil lawsuit that was brought by a patient naming Blush Med Spa as well as Christina Martinez. It's important to note that in that civil litigation, there was never a claim that there was any breach of the standard of care as it related to patient care. As the board and as Madam Chair may know, in order to proceed in civil litigation and making a claim of professional negligence, a certificate of good faith is required from a similar healthcare provider rendering an opinion that something that was done in connection with the treatment fell below the standard of care. That was never the issue in this case. And so as Attorney Newton indicated, that this matter pertains only to record-keeping shortcomings. As was mentioned, one of the allegations is that full informed consent was not obtained. There was an informed consent that was given by the patient, done so in accordance with the practices of the employer. The employer provided its staff, including Christina Martinez, with the informed consent documentation to be used in connection with the procedures that were performed. So while the informed consent failed to disclose certain things that were addressed by Attorney Newton, there was informed consent. It's true that the lot number and the expiration date of the Botox that was administered on June 6, 2022, the date that pertains to this claim, was not documented on that occasion. An examination of the chart related to this patient that spanned over a period of 12 months before this June 6, 2022 date indicated that on all other occasions, there was documentation related to the nature of the lot number and expiration date of medications that were provided. On this particular date, there was a physical assessment that was performed prior to the procedure. The chart failed to fully document the assessment. There were photographs before and after that were included in the chart, but the chart failed to detail the complete physical assessment that was performed on that date. And Christina has accepted responsibility for that conduct. With respect to the prednisone, it's also true that the patient was provided with a small quantity of prednisone as a courtesy to avoid a trip to the pharmacy. That was the practice of The employer verbal instructions were provided to the patient concerning the potential side effects. And those were also printed on the packaging that was provided to this patient. So it's important to note that Christina Martinez, over her nursing career that began in 2000, has no history of prior discipline. She was nothing other than a part-time salaried employee at Med Spa, was not incentivized in any way by commissions. She's always been a dedicated healthcare provider and has returned to her preferred practice in primary care. She's diligently worked to provide for her family, and she is currently doing so alone. So just to summarize, given that this matter is not related to the performance of any procedure, but rather limited to shortcomings in charting and providing less than an exhaustive informed consent, I'm respectfully requesting that the board reconsider its early decision and adopt the department's recommendations set forth in the consent order that's before you. Admittedly, I don't appear before your board on a regular basis, but I would respectfully submit that a civil money penalty in this instance appears to me to be disproportionate to the admitted shortcomings that have been outlined by Attorney Newton and addressed by me here today. And I again respectfully request that this board impose the recommended 6-month period of probation and the required coursework in prescribing practices and documentation, and that there be no civil money penalty. A civil money penalty in this particular case would be a hardship for Christina, and I believe it would be disproportionate to the shortcomings that have been addressed here today. So with that, I'll close and thank you all for your consideration of my request and for the opportunity to address the board here today. Thank you.
Okay. Thank you, Attorney, for that presentation to the board.
Thank you.
Both attorneys, Attorney Newton and the respondent's attorney. Okay, so I'm just going to ask for assistance with procedure from who is our attorney for the board today? Is it Attorney Bannon? I believe so. Or is it one of the other attorneys? Attorney Bannon.
Madam Chair, I'm here.
Okay, very good. Okay. So with regard to the procedure at this point, how do we proceed? Because we didn't pass this consent order last time we were together. It was denied. Obviously I can take another vote. How would I proceed? I just need that advice.
Bear with me one moment.
Oh, certainly. Take your time.
So this was presented as a motion for reconsideration. So I think that the board, if it wants to consider, would first vote on whether to grant or deny the motion for reconsideration.
Okay.
So if you grant it, then you can reconsider and you would have a discussion about the underlying consent order and then vote again on the underlying consent order. Alternatively, you can vote to deny the motion for reconsideration.
Okay. All right. All board members, I'm sure you heard Attorney Bannon speaking to us. So we're looking to see if we're going to have a motion for, to make a motion to either grant or deny the reconsideration of the consent order. So may I have a motion on that? And this is just, we're not saying we're passing the consent order. We're not saying we're saying we're either granting the reconsideration of it or we're denying the reconsideration of the consent order. Any board member would like to try that?
So I will start to get the conversation going. Hi,
Thank you.
this
Yeah.
is Sal. I motion to deny the reconsider consent order for Christina Martinez, APRN 2024-317.
Okay. All right. And may I have a second on that?
This is Liz Bannon. If I may, Sal, I wasn't clear on what your motion is.
To not approve the reconsideration.
So you're moving to deny the motion for reconsideration.
Correct. Yeah, I'm sorry. I didn't say it loud enough.
Okay, I just want the record to be clear for the minutes.
I put it that way so it's easier for voting, not a double negative. Yeah.
Okay. All right. And may I have a second? We are going to have a discussion and then we vote. So there will
This
be
is Cindy,
opportunity.
I'll second.
Okay. All right. Now we will open for discussion with regard to that motion one more time. And that motion is to deny reconsideration. Board members, any comments? Cindy, please.
Yes, the thing that still stood out to me from the respondents' counsel was that the blaming of the employer for her not doing a full physical, saying it was based on their document that they provide, and then also blaming the employer for administering the prednisone without an order and without documenting it. And that's not taking full accountability to do that. She's the one with the license. She's the one that was supposed to do the correct thing here. That's just my 2 cents.
Okay. All right. Thank you for your comment. Any other board member that would like to make any comments? Sal, I see your hand raised.
Sorry, I can't do two things at once. Yeah, I agree. I also think that just because a consent order, not a consent order, but sorry, yeah, the consent does not list something, you should be aware of it, and then you should inform the patient of that risk and then sign it. So she, as a practitioner, should have known that. Again, it's her practice. She's responsible, even though she's employed by somebody else. She's responsible for her own practice, and I think she failed in her practice.
Okay. I believe that Lisa, you have your hand raised.
Yes, thank you. I think informed consent is something that is so downplayed all too often. And it's perhaps to a patient the most important part of the pre-procedure. Patients are not medically trained, and therefore it is incumbent upon the provider to make sure that they understand the risks, they understand the benefits, they understand the alternatives, including doing nothing, and they need to be openly informed about every aspect of it that is relate to the outcome and procedure that they're undergoing. I think to downplay it as I forgot the term that the attorney used, and I respectfully challenge the minimization of, just a few details kind of thing, which is the impression I took away from his statement, although it wasn't said quite that, coldly. I support us emphasizing and holding the practitioner to standard that fully proper informed consent. It's not just signing a piece of paper. It's not just saying that the instructions were on the packet of the prednisone. It's a process of communication, and I think that we're just starting to do it a little bit better, but it has to be.
Okay, thank you, Lisa, for your comment. Any other board members? Okay. All right, so I am going to take a roll call on this motion. All right, and again, this motion was to deny, just so everybody gets that clear and there's no confusion on this. All right, so we will start. Cindy.
Aye.
All right, Sal.
Aye.
All right, Camille.
Aye.
All right, Lisa.
Aye.
Okay, Diane.
Aye.
Okay, and I, Jean, I
Were you able to
say
hear me?
I, Jeannie Reiner say aye. Okay, so that, obviously the motion passed to deny. Make sure I say that correctly on the record. So as we said, I believe last week, although the attorney wasn't here, the respondent's attorney, we're looking for you to go back to the drawing board, so to speak, with regard to this consent order. And that was my understanding from the last time we met. I don't have the date right in front of me, but okay. All right. Any attorneys, any questions or any comments? Okay. All right. So it's sort of going back to the drawing board of the concerns that the board members had mentioned with regard to the consent order. Okay, we will move on to proposed memorandum of decision. We have 1, 2, 3, 4, 5 of them. All right. There are, out of the 5, there are 3 that are requesting oral argument, but we will go in order that is presented on our agenda. So the first one is Michael J. Borelli, LPN. It's petition number 2025-213. It is for revocation. And so again, when we make this, these motions, and the board members are just amazing, but just want to reiterate, when you make your motion to just put that word proposed in, that's critically important, that these are proposed, and then we will go from there. So we will take the first one on Michael J. Borelli. May I have a motion on this proposed MOD from a board member?
This is Cindy. I make a motion to affirm the contents of the proposed memorandum of decision for Michael Borelli, LPN, petition number 2025-213.
Okay, may I have a second?
This is Sal. I'll second.
Okay, thank you, Sal. Thank you, Cindy. All right, we have a first and a second on the
Lisa,
proposed.
second.
Oh, Lisa? Okay, Lisa. All right, thank you. Attorney Bannon has her hand raised. Attorney Bannon?
Yes, I just wanted to chime in and give a quick piece of guidance here.
Yes,
Cindy, I
please.
think the way that you phrased your motion was fine, but might I suggest in the future, these are proposed memoranda of decision. I know that this is still a relatively new process for the board ever since the statute changed. So technically what you're doing is you're adopting the proposed memorandum as a final decision. So I think,
Okay.
my advice would be to include that term final decision somewhere in the motion to make it, crystal clear that that's indeed what you're doing.
Okay, thank you, Attorney Bannon.
Sure.
For that.
Thank you. I appreciate that.
Sure. Sure.
Okay, would you like Cindy to say that again? Should we say
Sure.
that?
Let's try it out.
Let's try it out. Okay, Cindy.
Take it for a test drive.
Yeah, exactly.
Okay, I, Cindy Arpin, ready to start adopting the proposed, make a motion to adopt the proposed memorandum of decision as a final decision in the case of Michael Borelli, LPN, petition number 2025-213.
Perfect. No notes.
Okay, excellent. All right. May I have a second again,
This is
please?
Sal. I'll second.
Okay, Sal second. All right. Open for discussion, questions, concerns, comments with regard to that motion. Okay. Sure, I can see everybody. Hearing none, I will now take a roll call. All righty, Cindy.
Aye.
Sal.
Aye.
Okay. Let's see, Camille.
Aye.
Lisa,
Aye.
Diane,
Aye.
and I, Gina Reiner, say aye. All right, so that proposed memorandum of decision has become a final decision. Right, so we're going to the second one, which is Margaret Bonterio, LPN, petition number 2025-1769, and that was for revocation. May I have a motion?
This is Cindy. I make a motion to adopt the proposed memorandum of decision as a final decision in the case of Margaret A. Monterio, LPN petition number 2025-1763.
69.
69, sorry.
Okay. May I have a second?
This is Sal. I'll second.
Okay, thank you, Sal. Thank you, Cindy. Now we'll open for discussion, questions, concerns. Attorney Bannon?
Sure, interjecting one more time. I just want to remind all board members that there is an expectation that your camera be on when you're participating in these meetings. Thank you.
Thank you, Attorney Bannon. Thank you. Okay. Yes, that would be really helpful because it's really tough for me to even find anybody if there's no camera, and especially the board members. So please, if board members can do that, and those that are doing that, I thank you so much. Okay. All right. So we had a first and a second, right? Let's just go back. All right. And open for discussion, comments, questions, discussion of any sort for the motion that was just stated by Cindy Arbin. Okay, hearing none. All right, I will take the roll call. Cindy.
Aye.
Sal.
Aye.
Camille.
Aye.
Okay. Camille, can you put your video on since we are talking about this at this moment? To be able to use your video? Is video available?
I said aye.
Okay, all right. Yeah, it would be important to keep your video on. All right, thank you. I appreciate it. The board appreciates it. Lisa.
Aye.
Okay, thank you, Lisa. Diane.
Aye.
Okay, and Diane, do you have your video on?
Yes, I'm right here.
Oh, okay. You might be on this next page anyhow. Okay, thank you. I appreciate it. I see it now.
Okay.
Oh, good. All right, thank you. Sorry about that. And I, Gina Reiner, say aye. Okay. All right, so that also passed. We will move on. All right, so the next one is Alberta Definis, I believe it is, RN petition number 2025-609. It is for revocation. This particular one, the attorney is, they're requesting oral argument. And so Attorney Newton is on this case for the department, and I believe it's Attorney Brittany Wallace. So first off, I see Attorney Newton, and I know that she's here. Okay. Attorney Wallace, are you in the audience?
Yes, I'm here. Good morning.
Okay. All right. Just trying to find you. Okay. There you are. I found you. Thank you. All right. And so is Alberta Definis, pardon me if I'm not pronouncing this correctly. Are you in the audience? Is Alberta in the audience? Okay. All right. So again,
No, she's not.
yes, hang on one second. This is a little bit different than for years and years of doing MODs and so for hearings and so forth. So I just want to make sure we're doing procedure correctly and get it down myself. So at this point in time, I'll just turn to Attorney Bannon and just request her guidance. Procedure-wise, am I having the respondents attorney make oral argument at this point? And again, it's just, we're not doing all testimony over or anything like that, but making an oral argument. Is that the right timing?
Yes, that's fine.
Okay, thank you. Okay, yes, Attorney Wallace, if you want to make your oral argument, go right ahead.
Thank you, Madam Chair, and good morning to the members of the board. And thank you for the opportunity to present an oral argument today. I'm here on behalf of Albertha Daphnis to respectfully
Oh, can people hear her? No? Okay, I didn't know if it was just my end, a problem with me.
This is Liz Bannon. She appears to have frozen.
Okay, all right, again. Oh dear,
request that she
okay.
be given a
Oh, there she
path
is.
forward.
She's back, I think. Okay, Attorney
she can-
Wallace, Attorney Wallace, pardon me for interrupting, but you froze, and please start your argument again because we didn't hear it.
Today on behalf of
Attorney Wallace, we are having difficulty hearing you. You're sort of in and out. There's an in and out situation, frozen again. Do you want to check on your technical situation?
okay, it seems okay from my end. My internet connection seems to be working. Can you hear me now?
I can hear you now. That's good. I can hear you strongly.
Okay.
Okay, so maybe take it again.
Okay. Well,
All right.
to request a path forward for Albertha Daphnis, for her to take the course that she was missing, as opposed to jumping straight to the revocation. She had been working for 5 years. She had no incidents. There was no harm done to any of the patients that she cared for. She's had glowing recommendations. She's able to convey complex medical information in a way that's easy to understand. And this is her life's work. She's extremely passionate about it. She passed the nursing exam. She does have an LPN, and she's looking to take the course prior to a revocation here. And that was what she was seeking to do. And that's what we would respectfully request the board to maybe even postpone the decision so that she can take the course that she's. Thank you.
Okay. All right, so bear with me for 1 second. Let me just look this up again. Okay, so Attorney Newton.
Yes.
Yes, there you are.
So-
Okay. Go ahead. Attorney Newton, can you just briefly review this case? Because we have an oral argument from the respondent's attorney, and just review this.
Thank you. Yes, the department is asking that the proposed memorandum decision be signed and to be granted as a final memorandum of decision. This is a respondent who did not complete the required program requirements and the nursing credits to attain a nursing degree. There were several inconsistencies in her transcript. She did testify that she attended Ideal from 2018 to 2019, when in fact her transcript reflected that she attended from 2016 to 2017. She testified that she transferred 74 credits from to Ideal from St. Vincent's College. However, the transcript itself indicated that she received 10 credits from Ideal from her LPN, and the Ideal transcript itself indicated there were no credits that were transferred from any other nursing programs. In addition, she completed the program at Ideal through online course with remote video and monitoring. However, the program outlined for Ideal did not permit any type of online coursework, and her the Florida board requirement required that respondent attend in-person instruction. So her online instruction was in contradiction and in direct violation of the Florida board's requirement that she attend in-person instruction. Accordingly, the department is asking that her license be revoked. She can always go back in the future and take the appropriate coursework and reapply for a license. Thank you.
Okay, thank you, Attorney Newton, for that synopsis for the board. Okay, so at this point in time, I'm going to ask a board member to make a motion. Again, remembering how we're setting this up, propose memorandum of decision. It's a proposed memorandum of decision, but will be a final one. I mean, the language. Okay, keeping that in mind, as Cindy illustrated to us and did a great job with a couple of them there. So may I have a motion, please?
This is Lisa. I make a motion that with regard to Albertha Deffinance, forgive my pronunciation. Petition number 2025-609, that we adopt the proposed memorandum of decision as the final decision.
All
This
right.
is Cindy. I'll second that.
Okay, Cindy's seconding. All right, so we have a first and a second. Any questions, concerns, discussion? Open for discussion from board members only. Okay. All right, hearing none.
Can I
will
just,
take
can
the-
I, do you know?
Yes.
Can I, this is Lisa. I just want to add that there
Yes.
are so many, getting a nursing degree is more than just on paper. And I appreciate that the nurse's practice has been apparently very good. But what we can't tell when they've missed certain things that document knowledge, we can't tell what they don't have, what experiences they haven't had that we assume were covered during the educational process. And it would be a shame to find that out at some point, that, oh my God, she was never fully instructed on that, that particular task or technique or whatever it might be. So that's why there are standards. And I think it's very important for our board to hold those standards in very, very high, without exception.
Okay. All right. Thank you
Thanks.
so much. Appreciate your comment, Lisa. All right. All right. So I will now take a roll call. Cindy,
Aye.
Sal,
Aye.
okay. Camille.
Aye.
All right. Let's see, Lisa.
Aye.
Okay. Lisa say aye. Diane.
Aye.
Okay. And I, Gina Reiner, say aye. All right. So this proposed MOD has become a final MOD. All right. We will now move on to our fourth one. Fourth proposed memorandum of decision on Peggy K. Kayumba, RN, petition number 2025-276. It is for revocation. And Attorney Newton is on this case. And I believe this is also another oral argument. And the attorney is Attorney Miller. Pardon me, my fax machine is going on. Hopefully you all can hear me. I'll talk louder and then I'll obviously put my mute on while others are speaking. Just want to apologize for that. Okay, is Attorney Miller in the audience, first of all?
I am. Good morning. Good morning. That's correct. I'm here for oral argument. I'm Robert Irving Miller, and I represent Peggy Kayumba, RN.
Okay, thank you very much. All right, excellent. All right, so I will go with you, Attorney Miller, giving your oral argument. Then I will go to Attorney Newton to review the case with us briefly, as she did the last case. And then we will go to a motion. So go right ahead and do your oral argument, Attorney Miller.
All right, thank you. So I'm not here today to retry the facts. The board has before it a proposed decision prepared after a full hearing, and that hearing narrowed down the issues. If Attorney Newton later talks about there were alleged discrepancies or things like she did with regard to the last respondent, the hearing decision focused entirely on the clinical education that was provided at the midlife program in Florida that Peggy attended there, and from which she received a degree. So assuming the board accepts the factual findings, that's fine. The question is, what is the fair and reasonable and necessary remedy? So the proposed decision concluded after removing all the extraneous allegations, that the 4 clinical credits awarded by MedLife to Peggy Kayumba should not have been counted toward her associate degree because the clinical component that she attended, that the school directed her to attend, consisted of what turned out to be simulation exercises and head-to-toe assessments of the students on each other, rather than the type of clinical experience required under the Florida board's approval of the program. Now, people who attended MedLife for years are still practicing in Florida. It looked and sounded like a legitimate school, and the students, when they got there, were told what classes they had to take in order to graduate. And there's no indication that there's nothing about the students having been put through this that indicates any wrongdoing on the part of Ms. Kayumba. But what are the consequences of that finding? What's been established? There's an educational deficiency, fair enough. And I agree with those who said this is all about protection of patients. That's fine. The record does not establish that there's ever been any patient harm involving Peggy Kayumba. She came to this country as a teenager, attended high school in New York City, thereafter attended the University at Buffalo, where she earned 118 credits in residence at the university there. She subsequently took the training to become a certified nursing assistant. And then she went to school for a year to become a licensed practical nurse. Ms. Kayumba is an LPN in New York. And then she went to the Helene Fould School to work on her associate degree and become a registered nurse. She and many of her classmates, inexplicably, did not complete just the last course, MedSurg 2, and they looked for a way to make up those credits and earn an associate degree. And MedLife represented itself as being able to do that in a somewhat accelerated program that they traveled to Florida to attend over the course of a few months. But there's no, so after that, receiving that associate degree in 2016, Peggy began working full-time at Brookhaven Medical Center, a very busy place in Brooklyn, as a med-surg nurse. She worked there all the way through until August 2025, when she was summarily suspended by Connecticut. And then that came to the attention of her employer, and they just terminated her employment as a matter of course because she'd lost a license. Peggy's never practiced in Connecticut. She was going to move here with her husband, but then they got divorced. She's now a single mother, and she's very much dependent. It's a real hardship if she doesn't have a job. All those years she worked at Brookhaven, just like the years she worked in a nursing home as an LPN before that, there's never been a question about the quality of Peggy's work. There's never been any question of misconduct, no complaints about her practice. There's no evidence of that at all. After attending the University of Binghamton and the LPN program, the CNA training, and the Helene Fould School and MedLife, Peggy earned a bachelor's in science degree in nursing at Chamberlain University. She subsequently earned a master's degree, Master of Science in Nursing at Purdue University, from Purdue University. And all of that is now on the line because of what occurred in Florida. So you put yourself in that position. This is potentially devastating to someone who has worked safely as a nurse, much needed nurse, worked through the pandemic, worked taking care of patients her whole life as an adult. And I'm not asking the board to disregard the educational requirements. Peggy's not asking for special treatment. We're just asking for the opportunity to cure this deficiency. And she's willing to make up the credits, even to pursue another associate degree from an accredited school. We would need and request a stay of revocation for about 18 months so that she can accomplish that. Why do I ask that? And that's within your power. But why do I ask that? Because when someone's license is revoked in any other state, that travels around. Her license in New York will be at risk of being revocation. She's still licensed in Florida, although she has not renewed the registration there. That license will be at risk of revocation. And her LPN license is jeopardized, not for licensure purposes, but she may be prohibited, based on the revocation in Connecticut, from practicing as an LPN or in any other capacity at a place that accepts Medicare or Medicaid. Any medical practice or hospital. This is a devastating thing, and it really has consequences for someone who's an LPN. I would note that if Peggy had attended Excelsior College in New York, in the LPN to RN program, that's an external degree program with all remote training and is accepted by Connecticut for LPNs to become RNs because of all the clinical experience they have. So in terms of patient safety, the fact that the training was in a laboratory environment and a classroom environment rather than in a hospital or nursing home, for that to now, we accept that needs to be remediated. But that's the solution, remediation, not revocation of the license. Revocation does not improve a single patient outcome. If you do not revoke, Peggy should have no trouble continuing to work at least as an LPN and on her RN license in the other states and continue to take care of patients safely as she has been doing. And you'd be ending her nursing career after all these years of effort. I mean, her first language wasn't even English. She came to the United States. She had to learn English as a teenager. She grew up in a francophone country speaking French. So she's really worked very hard to get where she is. And basically the revocation would be disproportionate to this limited problem with regard to what the clinical training was for those 4 credits. So a revocation gets reported to regulatory and credentialing agencies and can really create significant consequences affecting her employment, her credentialing. It already has. When she was summarily suspended by Connecticut, she lost her job. She'd been working there since 2016, 9 years, full-time, and going to school and raising a child, and then she lost her job. So these consequences are very severe. There is absolutely no indication that Peggy is unsafe. It was troubling that the summary suspension said, oh, she poses a risk to the public. When people work successfully at a medical center, and there was evidence before the hearing officer, not testimonial evidence, but evidence from a nursing supervisor or manager who had worked with Peggy, that she is safe, that she's a good nurse. She's an excellent nurse. We need those. So we respectfully ask the board to stay any revocation for a period of 18 months and require completion of board-approved educational remediation during that period. That's within your power. If Ms. Kayumba successfully completes the required education, the public is protected, the identified deficiencies corrected, and if she were to fail to do so, the board retains full authority to impose revocation at that time. The suspension would, we understand, remain in effect, so the public is protected under that. We would just ask that that be continued, but the revocation not be imposed. The MedLife created that program. Peggy Kayumba did not. She was a student. She went to school. The school is the authority. They tell her what to do. She did not determine how the credits would be awarded. So we're not here to defend MedLife, and I certainly understand the board's concern about that school and the things that went on. But in the case of Peggy Kayumba, you now have a better sense of who she is and why her license should not be revoked at this time. She should be given an opportunity to correct and remediate the educational deficiency, because in all other respects, the public is protected. Thank you.
Okay, thank you, Attorney Miller. Attorney Newton, can you just give us a brief synopsis on this case?
Yes, good morning, Joelle Newton for the department. The department is asking that the board grant the motion for the proposed decision to become a final decision. This is a respondent who attended a nursing program at MedLife in Florida. All states, including Florida, have requirements to make sure that nurses are properly educated both in instruction as well as in clinical skills. MedLife program did not include any simulation or online clinical instruction, and respondent testified that her clinical education included simulation and head-to-toe assessment on fellow students. Thus, she did not properly complete the program outline and the requirements to be awarded a nursing degree. Because she doesn't have the requisite nursing requirement, clinical skills and nursing education, the department is therefore asking that the revocation be put in place. Respondent does have the opportunity to go back to school and to make sure that she is properly educated in her skills to protect the public health and safety. And because of that, the department is asking that the proposed decision be finalized as a final memorandum of decision. Thank you.
Okay, thank you, Attorney Nguyen, for that synopsis for the board. Okay, I will ask a board member to make a motion, and keeping in mind the language of proposed memorandum of decision and final, putting that word final in. Lisa, you have your hand raised. Lisa, can I ask you if you could put your video on, if able to do that? Because we can't see you. So just trying to get the board members to have their videos on. There you are. Great. Okay, and you have your hand
Okay,
raised. You have a question?
Yeah, yes, thank you. I did turn my video on. However, I am having problems with my signal strength. And
Oh, yeah.
if I don't have my video on, it gives me more bandwidth. So if it's okay, I would ask to allow me to take it off because I was hearing much better. It's getting all chopped up. Well, I'll do it until it gets chopped up again because right now I'm good.
Okay.
Yeah,
All right.
I just want to say, and unfortunately, it's kind of a repetitive thing because this issue keeps coming. But it's not good enough to say that the person has not done anything wrong at this point and they've proven to be a good nurse and everything else. I'm so glad we have good people out there, but nothing has happened until it happens. And as a patient representative, I don't want to wait until it happens. We have established educational standards in the state of Connecticut because those are the standards that are felt to be necessary so that we can be certain that a nurse has been properly and well trained. What happened through this whole situation, life and the other affiliated schools, is that it was a fraud. And unfortunately, very good people got caught up in that fraud. It's not their fault for sure, but we have to look at the whole thing, and clearly there's been a lot of misrepresentation through the educational process or non-process perhaps that was offered down there. The situations, to my experience, vary a little bit from each one to another. There some nurses or some students got some training, some students got other training, they had certain experiences. And the problem is that what we do know is that the education was not consistent, that it was their program was there, not the education, but the program was there so that the people behind this fraud could make money. And it breaks all, I behalf of the board, it breaks all of our hearts because we're all proponents of a very strong healthcare system here in Connecticut. And I'm not a nurse, but I've had too much experience in care. So the only way to make it worthwhile was that I've become an advocate. I think what has to be appreciated is that her LPN license, from my understanding, has not been affected by this. She got her license. It stands. It doesn't get diminished. Her knowledge and her experience are very much respected in the industry, and I think that should be looked into by the respondent. I have no doubt that she's a good nurse, a good person, but we can't vouch for the safety of the patients because we don't know what hasn't happened, or we don't know because of what hasn't happened. So I just want to say that it is unfortunate and it's not fault, but it is something that we have to do. And consistently, we've been doing it because we really do have to protect the integrity of the RN license and beyond. And we hope that everybody who gets affected by it can get their feet back on the ground firmly, because they do have good intent. So, as a result, I'm going to support finalizing the memorandum of decision, but I just want to say that it's complicated and it's not easy for us either, because we do have heart. But this is about things bigger than just heart. Thank you.
Okay, thank you, Lisa. And so at this point, I would ask a board member to give me a motion, and we will do a motion at first, a second, then we'll open for discussion, and then we'll go from there. Keeping in mind the language of the motion.
This is Cindy. I'll make a motion to adopt the proposed memorandum of decision as a final decision for Peggy K. Carumba RN petition number 2025-276.
This is
Okay.
Diane. I second that.
Okay, thank you, Cindy and Diane. All right, so we have a first and second, open for discussion. I know that Lisa just made a comment, so we obviously heard her comment. Any other comments? Discussion from board members only. Okay, Lisa, I see your hand raised again. It may just be up. Okay. All right, I think it's just
I can't
up.
pull it down.
Oh, okay, no problem, no
Try.
problem. No concerns. I'm sure it's technical or whatever. Okay. All right, so there's no more comments, so I will take a roll call on this. All right, Cindy,
Aye.
Sal,
Aye.
Camille,
Aye.
Lisa,
Aye.
okay, Diane,
Aye.
and I, Gina Reiner, say aye. All right, so the proposed memorandum of decision, that is the final decision, has been affirmed, has been approved. Okay, we will move on to the
This is
last.
Liz. This
Yes.
is Liz Bannon. I just want to interject very briefly that I think the board needs to also address Attorney Miller's oral motion to stay the enforcement of the board's order. And I can give the board a little bit of guidance on that. Attorney Miller, do you wish to, withdraw your motion or have the board vote on your motion at this point? You're muted.
I would request that the board address the motion as it stands and vote on the issue of the motion. Thank you.
Okay, and Attorney Newton, I don't know that you necessarily addressed the motion, the oral motion for stay. I don't know if you'd like to be heard on that.
Yeah, the department objects to the motions for stay and asks that the memorandum of decision, the proposed memorandum decision be adopted as a final memorandum. Thank you.
Okay, so I just want to advise the board that with respect to motions for stay, those are authorized under the statutes, and there is case law that governs, that but either the board or the court can hear a motion to stay, and the case law that governs kind of the board's consideration of a motion for stay is called it's a test. It's the balancing of the equities test. And essentially, it requires the movant to demonstrate that there will be irreparable injury. Excuse me, actually, bear with me one second. I'll just read this. I'm quoting, this is a Superior Court case, but Griffin Hospital v. Commission on Hospitals is kind of the case that stands for the balancing of the equities test. And it's a test which weighs the equities and balances the harm that may be suffered by the applicant as a result of the enforcement of the agency order or the decision pending the appeal against the public harm that may result in the delaying the effectiveness of the order or decision. So it requires you to consider the likelihood that the movement will prevail if the order is appealed, the irreparability of the injury to be suffered from immediate implementation of the agency order, and the effect of the stay on other parties to the proceeding, as well as the public interest involved. So those are the considerations. And that's I put that forth to the board to consider Attorney Miller's oral motion for stay.
Okay, so do we need, Attorney Bannon, it's Gina speaking, obviously. Do we need a motion to affirm or deny his motion for stay?
It would be essentially a motion to either grant or deny
understand.
the motion for stay.
Okay, let me just jot that down because I don't think we have ever had that motion to either grant or deny. And board members maybe take a note, the motion to stay. Okay, hang on a sec. All right.
And if any board member has a question about anything I've just said, please ask.
Yes, please do. Cindy, you have your hand raised? Go ahead.
Yes, I have a question about this. So didn't, by allowing or having Attorney Miller just give his testimony or his statement, wasn't that allowing this stay? How different would it be what's the difference of whether we say yes or no to the motion to stay?
So Attorney Miller's argument was essentially his motion is asking the board to stay the revocation of his client's license. So what that would mean is if you granted the motion, her license would not be revoked. The decision would be held in abeyance. It would not be effective. And he's asking, I think Attorney Miller, correct me if I'm wrong, it was for a period of 18 months.
That's correct.
Okay. So the fact that we just voted to adopt the proposed memorandum of decision is separate, even though it really does cover that.
Yeah, and I did consider that. And Attorney Miller, I would defer to you. I mean, I believe that a motion for stay is really asking to stay a final order. And so the board voted to finalize the proposed memorandum of decision. And he's asking you to stay the effect of that order. So he's asking you to not revoke the order was issued, you adopted the final decision today. So we have a final decision, which is ordering revocation. He's asking you to put that on hold for a period of 18 months. And Attorney Miller, please jump in. I don't want to put words in your mouth.
I think that's it. I mean, we see that people are in various jurisdictions their licenses are sometimes suspended, but the suspension is stayed. In other words, the effect is stayed so that they can continue working, but they are on a very short leash. This is a little different from that because Peggy is already suspended. We're not contesting the suspension. That would remain in effect. It's just the revocation has implications for, frankly, you can get placed on the Medicare, Medicaid exclusion list at the Office of the Medicare Inspector General, and because your license is revoked, and being placed on that list puts a person, you cannot, once you're on that list, you cannot work in any position, even as a housekeeper or a cook at a place that receives funding through Medicare or Medicaid. So she would be unable to work as an LPN, even though her LPN license is not in question here. So that's the basis for my request for a stay, so that she can continue, because it becomes very difficult to untangle the OMIG response to a revocation, and it would put her out of work. So this way, if she can just continue to remain suspended and the revocation is stayed, I can work with OMIG on that to allow her to continue to work as an LPN. And then in the meantime, she's been busy looking into schools to get the necessary degree at this point.
Okay, Attorney Newton, you have your hand raised. Go ahead, Attorney Newton.
Yeah, I would just like to add that it's my understanding that she would still be permitted to work as an LPN. It's my understanding that there are nurses in this exact same situation who are continuing to work as LPNs.
Yes.
Okay, thank you, Attorney Newton, for your comment. All right, so board members, we're looking for a motion to either grant or deny the motion to stay. All right, and make sure you understand what that means. We have a final motion now. And the motion, if you grant the motion to stay, you're saying, you know, the revocation off the table and it's 18 months, right? And the respondent stays summarily suspended, just so we were clear. All right, so I hope I have that correct. All right, so I think, Lisa, do you have your hand raised? I think that might be technical. Okay. All right, may I have a
Yes, I
motion?
do. I do.
Oh,
No, I do. I'm confused. Yeah, I'm confused about our
okay.
my understanding is that the LPN license does stay intact and everything, but if it
Yes,
really doesn't, I don't feel
It
that I know
does.
enough about that part of the law. It stays, I'm sorry, Cindy, did you?
her LPN license, this is Gina speaking. Her
Okay, so
LPN
to
license
my
is not
understanding, up
being
until,
yeah, the LPN license is not being revoked. And there's no statement of charges
okay,
against her LPN license. We have Attorney Bannon with us. She can stop me and interrupt me and give us guidance. But there's nothing happening with her LPN license. She can go work as an LPN. That is my understanding. My other colleagues, board members, if you know, chime in. I see Cindy
That's my
shaking her
understanding
head.
as well.
Okay,
And
chime in.
Attorney Newton just said
this-
as much.
All
This is
right,
Liz
so
Bannon. I'm confirming that this memorandum of decision, the petition was filed as to her RN license only.
right, that's what I have in front of me too, the petition number and the RN license, and I have it printed out. So this has nothing to do with the LPN, and many of the Nightingale cases have gone and there was a couple of articles on this and utilize their LPN license, and then they have a choice of going back and, you know, getting the education, the gaps or whatever
so,
they need. Okay.
yeah, so that is what my understanding is and was, but Attorney Miller is saying that Medicare and Medicaid specifically in some way will not hire a nurse who's had their RN license revoked, even if they have an LPN, excuse me, an LPN license that is active and unimpinged. So is there a regulation or something that specifically says that we can refer to? Because I don't feel comfortable staying it under, if we don't have to. I don't. We necessarily
Okay, Cindy,
want
you have your
to
hand
put
raised.
a nurse in a position where
Yes.
they really can't do any level of nursing, even if they have an LPN license.
Cindy, you have your hand raised. Go ahead.
Yes. The issue at hand here is her RN license, and she did not receive the adequate education to have an RN license.
Right.
The fact that she has the LPN to fall back on is great, but even if she didn't, she still did not receive the adequate education to be an RN. And we need to move forward with that. That's the question, not what she can do besides being an RN.
Yep. We're always looking at the statement of charges before us.
Right.
There's an RN license. That's my understanding. And you know, obviously look at the hearing that proceeded and so forth.
Right.
So we're not going to, my opinion is that I'm not going to get into
concerned.
CMS or Medicaid at this point, you know.
Okay.
Yeah, but I mean, you have every right to ask the questions.
So we're
I
going
don't
to
know if
just
we
go
have an
based on
answer.
what we've known up until now.
Attorney Bannon, do you have any comments on this for us or any words of wisdom?
I'm not really hearing a legal question pending. I'll reiterate this decision. The petition was filed as to her RN license only.
Okay. Thank you. All right. So again, we need a motion to either grant or deny the motion to stay.
This is Cindy. I'll make a motion to deny the motion to stay in the case of Peggy K. Caramba RN petition number 2025-276.
Okay, may I have a second?
This is Sal, I'll second.
Okay, all right. Any questions, concerns, discussion? Sal, you have your hand raised?
Yeah, I mean, again, I want to put out there that she is not educated to practice as a registered nurse. And so this is extremely important to us, and that this is why we are making this decision. Why I'm making, Sal Diaz is making my decision, is because she hasn't received the proper education to practice as a registered nurse. Thank you.
Okay, thank you, Sal. All right, so I will now, let me just make sure, any other discussion from board members? Don't want to jump ahead. Okay. All right, we're good. All right, so I'll take a roll call. And again, Cindy's motion was to deny the motion to stay. Make sure I got that straight. All right, Cindy.
Aye.
Sal.
Aye.
Camille.
Nay.
Okay. Lisa.
Aye.
Okay.
That's to deny the
Diane.
stay, correct?
To deny the stay. So you understand, okay?
Yes.
All right, good, okay. Diane?
I did.
Aye.
Okay, repeat that, Diane, I just didn't hear you.
Aye.
Okay, thank you so much. And I, Gina Reiner, say aye. So the ayes have it. We have denied the stay. The proposed memorandum decision became a final decision. Okay, and the decision was revocation. All right.
No, I
We'll
just
continue.
want to clarify that was a motion that denied the motion for stay.
Yes, yes.
Yeah, okay.
Thank you. Yes.
Thank you.
Yes, I understood that. Maybe my language was off a little bit there. All right, so we will now continue on to our next agenda item. Rochelle George, RN, APRN, petition number 2025-299 and 2025-298. Linda Fazina is the staff attorney. And I believe the attorney for the respondent is Arnold Ira Menchel, I believe the name is. But first, Linda, can you, Attorney Vizina, pardon me, introduce yourself so I can find you on this board?
Yes, good morning, Attorney Linda Fazina for the department.
Thank you. Thank you so much, Attorney Vizina. Okay, and is Rochelle George in the audience? Rochelle George.
Good morning. Yes, I'm here.
Okay, thank you so much. Okay, I can see you. Thank you. I appreciate that. Leaving the video on would be really helpful. Okay, and let's see, is attorney, I hope I'm getting the name right here, Arnold Ira Menchel in the audience?
Yes, I am. I'm here if you can find the right box to.
Yes, I found you. Thank you.
Thank you.
All right, I see you. Thank you very much. I appreciate it. All right, very good. All right, so you are requesting oral argument, Attorney Menchel, and what we'll do is have you give your oral argument. Then I will go to Attorney Fazina, who will give a synopsis of the case for the board, okay? And then we will go into motions after that. So if you would go right ahead and do your oral argument, Attorney Menchel, that would be appreciated.
If I could just start out by, our situation is very different from the ones that preceded you, because we're here to support the proposed memorandum of decision. So I would suggest, and Attorney Bannon will obviously advise you, but because I would like to hear what Attorney Fazina has to say about the proposed memorandum of decision in Ms. George's favor, before I go.
Okay, yes, unless that's not the right procedure, and Attorney Bannon will let me know, but I will let Attorney Fazina go right ahead and present.
Well, thank you, but the department did not ask for oral argument, so I'm a little bit confused
right.
about today's proceedings and the order that we're going in.
Okay, all right. I stand
All right,
corrected.
well, if Attorney Fazina is not opposing the memorandum, then obviously I believe it was correctly issued. This is a legal proceeding, and the hearing officer rendered a decision that was well supported by the record that Ms. George did receive or there was no evidence in the record that she did not receive the education, that there was no reason for her to know all of the operative statement of charges were not proven. So, yeah, I just definitely would support the approval of the proposed memorandum as a final memorandum.
Okay, just thank you, attorney. Just so to just go over this for a moment. So according to the MOD, the proposed MOD, based on the order says, based on the record in this case, the above findings of fact and conclusions of law, the board orders that the summary suspension order suspending the respondent's registered nurse and license, and that has a number, and advanced practice registered nurse and license has a number, is vacated and the charges are dismissed. So everybody's on board. Obviously, the board members received all this documentation. So we were looking at vacating the suspension order according to this proposed MOD and having the charges dismissed. Okay, and so obviously the respondent's attorney, I shouldn't say obviously, but obviously the respondent's attorney is in favor of this, and there is no oral argument from the department, Attorney Fazina. And so my understanding is I just proceed with a motion from the board members with regard to the language. Then we will have a motion for obviously granting, denying, whatever, and then we go into, excuse me, discussion. So may I have a motion?
This is Cindy. I make a motion to deny the proposed memorandum of decision as a final decision in the case of Rochelle George RN APRN petition number 2025-299 and 2025-298.
Excuse me. Okay, so we have a first, and it's for denial of the motion. Okay, may I have a second?
This is Sal. I'll second.
Okay. All right, let's, at this point in time, board members only, we will open up for discussion. So I had to read this over several times, like seriously. Cindy, go right ahead.
Okay, so I have a few notes, so bear with me as I go through that. So in looking at this, it looks like the respondent attended 12 days of classes and no clinical at MedLife to receive her associate's degree. She was awarded credit for a failed course that she took at Helene Fuld, and the argument was that she passed the clinical part of it, but not the didactic part. But the course, when you look at it in the transcripts, it's not separate. And in my 12 years as an educator with a doctorate in nursing education, I've never heard of someone being allowed to dissect a course that wasn't a separate course. So if you fail the didactic part, you fail both the didactic and the clinical. And so I don't think she should have been awarded those clinical hours. Let me just hang on one second. Also, the affidavit from the owner of MedLife has been routinely accepted as a legal document by the FBI and boards of nursing across the country. And also when talking about the transcript and not knowing whether to allow that clinical to be accepted, the hearing officer said that they did not have any experience in reviewing transfers and was not, didn't have that expertise at all. And they admitted that. Let me just look here. I think those were my biggest things, was that we're allowing credit to be given for clinical hours from a failed course, and that's not how nursing education operates, in my experience.
Okay, thank you, Cindy, for your comments that you shared with us. Any other comments from board members?
I would like to be heard because I was, again, waiting to hear what the arguments were against
Okay.
it. So when you're done, before
Okay.
you take the vote,
Yes,
I'd like to be heard again, please.
yes, definitely. You'll have your time for oral argument, attorney, definitely.
Thank you.
Okay, you're welcome. You will. All right, any other comments from board members? We'll stay with this, and then we'll go to the attorney for his oral arguments. And then if we need be, we'll go back and have more discussion after we hear his oral arguments if needed.
Again, this is Sal.
Yes, Sal.
And I too have my doctorate in nursing education, and clinical hours are not awarded here in the state of Connecticut on courses that you fail if the clinical is within the course. So those hours do not count and should not count towards her degree. And then again, she doesn't meet the requirements. And so this is my concern. And I understand it's an unfortunate mess that this young woman is in with this. But again, we have to follow our educational guidelines and our requirements here in Connecticut. And this does not meet our requirements, in my professional opinion.
Okay, thank you. Thank you, Sal. As I said, I'm making a comment myself, Gina Reiner speaking. It was very confusing with regard to this case. I sincerely read it over and over again. And, I was, if I may say this, with all due respect to all, I was quite surprised. I don't know if that's the right word. That's probably not a very professional word. I think of I'm not a lawyer, but of the order of this. And so, yeah, I've gone through everything that I can think of, and I had some of the same notes as Cindy. But I am anxious to hear from the respondent's attorney, because I'd like to hear that piece of the case. So why don't, any other board member comments? Maybe it would be really helpful if we hear what the attorney has to say, and we can come back if that process is appropriate. All right, why don't we do that? We'll go to the attorney just to hear that side. All right, we've got our document in front of us from the hearing officer. Okay, that's the piece that I'm DPH is hearing officer. So attorney, pardon me for Menchel, attorney Menchel, go right ahead and make your oral argument so we can hear.
Well, thank you. Thank you very much. And I recognize that this is a different type of proceeding than the board has engaged in the past with a hearing officer. The hearing officer is actually the board's hearing officer, not DPH's. The person who did it is employed by DPH, but he was acting on behalf of the board, not on behalf of DPH. DPH was putting on the case. And the key that, and I understand, the comments that the board has made, but what you have to understand here, and Attorney Bannon, just as an aside, I represented the state for 33 years in the Connecticut Attorney General's office. So Attorney Bannon will be, advising you as to the law, but I was in that position for many, many years. But the fact is, this is a legal proceeding. And so the law governs what has to be done in order for the statement of charges to be proven. And so it's not a question of, well, what's familiar to you folks. But the fact of the matter is the statement of charges made certain allegations, and that's all they were. They were allegations against Ms. George. So the first one, and the one that's the concern that's been expressed most often that I've just heard, not only in this case, but in the prior cases, was that she didn't get the education that she was required to get. The finding of your hearing officer, who is legally trained, he's a lawyer himself, was the burden is on DPH to show that everything they said in that statement of charges is true. That's not Rochelle George's burden, that's DPH's burden. And what did they have to show for that? And I know you said that the affidavit is, what you guys have been relying on. But the fact of the matter is the affidavit is what's called hearsay. And while hearsay under certain circumstances is allowed in administrative proceedings, the fact is it can't, if it's not sufficiently reliable, it can't be the basis for a finding of culpability against Rochelle George or anybody else. But the fact is, in this case, I had specifically asked that they produce Mr. Tanis so that we could ask him questions. In order to be acceptable hearsay, like, so for example, and you folks will understand this, medical records are generally, they're hearsay. The doctor may not be there, but the notes come in, and that's fine. That's considered reliable hearsay because the doctors don't have any particular axe to grind in one direction or the other. But here, the affidavit, and there's a case law on this from the Connecticut Supreme Court called Kozlowski, which I've cited in the brief. Kozlowski said that you can't use it if it's not reliable. In order to be reliable, it's got to be trustworthy and probative. And the Tanis affidavit, standing on itself, is neither one of those things. It's not reliable because he was a convicted felon and being charged with a second felony when he made this affidavit. And so, he was throwing everybody he could under the bus to try and save his skin. So that's not reliable. It's also not probative because it's a one sentence in a one-page affidavit that says anybody who didn't live in Florida didn't complete the required program. Well, Rochelle George didn't live in Florida, but she traveled to Florida. She completed the program. So what does the affidavit say about that? Nothing. There's no, and that's why there's no chance for us to say, well, what about that? And the evidence was that Rochelle George was sitting next to people from Florida. And so if anything, the Tanis affidavit supports Ms. George in that it implies, at the very least, if it implies anything, that if you did reside in Florida, then you did earn the degree. So therefore, if the person who was sitting next to a Florida person attended the very same classes, got the very same education, then why is the Florida person acceptable and the other person not? So that's why that affidavit doesn't prove paragraph 6 in the statement of charges. So there are three paragraphs that in order for you to, sustain the statement of charges, then you need to find that 6, 7, and 8 were true. And there's just no evidence of that. Now, the other affidavit was from Sherry Sutton Johnson, who said that, well, they weren't allowed for online education. Well, the hearing officer, your hearing officer, found as a finding of fact, and the hearing is closed at this point, that she went in person. Just because the use of the Blackboard platform to submit homework assignments and to submit the homework in return. Well, this is the 21st century. It wasn't this way when I went to school, but nowadays that's what schools do. Not just MedLife. People in all kinds of schools go and submit their homework and get their homework assignments electronically. So that didn't negate that she went in person just like the Florida people went. Now, MedLife Institute, and I understand people say a lot of things about MedLife Institute, but when you look, again, Sherry Sutton Johnson's affidavit, if it shows anything, it shows that in fact, MedLife Institute was accredited by the state of Florida through 2019 or into 2019, 3 years after Rochelle George was given her diploma. So they didn't take away MedLife's, and then they allowed them to teach out. So therefore, you've got the only 2 affidavits, which themselves shouldn't be allowed to stand on their own with no other evidence. Their affidavits, if anything, point in Rochelle George's favor, which is why the hearing officer found what he found. And so then you go to the paragraph 7, and paragraph 7 says that she knew or should have known that the claim that she had completed the required coursework was false. Well, again, there's absolutely no evidence whatsoever that Ms. George should have known that. She, as the record and the only evidence that's in this case will attest, she checked it out. She went and looked and it was accredited. And, and that gets us to paragraph 8, which the statement of charges alleges that she misled the department into thinking that she got this. She didn't mislead the department at all. There's absolutely no evidence that she misled the department. The fact is, she put it right on her application. Where did you go to school? MedLife Institute. She put on all of her renewals that she went to MedLife Institute in Naples. She didn't mislead anybody. Now, and keep in mind, the hearing officer did not go through all of the evidence, because we put in additional evidence that the department at the time knew exactly what was going on, and they gave her the license anyway. But the fact is, that's a key that MedLife Institute was accredited at all times that she went there and when she got her diploma. She didn't mislead anybody. She didn't say, oh, well, I went to Columbia, and letting you believe that she went to Columbia University when she went to Columbia High School. You know, she didn't, you know, say something that was partially true but intended to deceive. She didn't do any of that. She didn't mislead anybody. There was no way for her. She didn't know until 2025 when she got this investigative letter that that there was any question about her education. So it's not like she pulled this fast one on DPH and the board. You know, she did everything that she was supposed to. And the fact of the matter is there just isn't enough law, you know, to support the hearing officer, you know, to support the statement of charges. As the hearing officer's findings themselves said, another key portion, and this was something that somebody, I don't remember exactly who said it, that she may have been Lisa or Sal, somebody said that she failed the course. She did not fail the course. She got a C in the course. Helene Fold has a separate requirement that in order for us to give you a diploma, you have to get a C+. But the transcript, the evidence, you've got to go by what's in the evidence, what the evidence shows in the record, and the record is closed. The record shows that she got a C, not an F in that course. So so she did not fail that course. So she did get the education. In addition, as the hearing officer pointed out, in terms of the clinical, she was at Bronx, Lebanon. I have those places, but it's all in the brief. Bronx, she went to 3 hospitals where she did her clinical work. So she got all of her clinical work done. She got all of her coursework done. You know, 62 of the 72 credits were done at Helene Fold. So that part, nobody questions Helene Fold. That's where she got her clinical experience. So the fact is, you've got to look at this as a legal proceeding. And the fact is there are other things. If this, you know, there's no way, and the fact is it's telling that the department did not ask for oral argument regarding the hearing officer's determination. So the fact is, if you were to deny or to reject this decision, you'd have to go back to the evidence that's in the record. And one more thing, and again, Attorney Bannon can advise you on this, but the case law is very, very clear that, you know, for you guys to use your expertise, you had to give us notice and an opportunity to be heard. It's called fundamental fairness, and there's a case Feinstein versus Conservation Commission of Newtown, 180 Connecticut 421, Parsons versus Board, United Jewish Center versus Town of Brookfield. These are all cases that say fundamental fairness is violated if an agency is going to use its expertise and not give notice of what that expertise is and not give the facts that as they see them. So this is, you know, not to mention, so first of all, that decision you can't reverse it and revoke like you did in the others where the proposed memorandum was for revocation. So you can't just go the opposite direction with Rochelle. The fact is there are other arguments that I made that weren't addressed in the memorandum of decision, including the fact that there's something called promissory estoppel that, you know, even if they had proved it, you wouldn't be able to do it. So it would have to go back to the hearing officer for a decision on those facts as well. So, you know, in some, there's nothing, this is a legal proceeding, and as a legal proceeding, there's no evidence that's sufficient in the record to support the actual statement of charges as set forth, and the hearing officer got it right. Thank you.
Okay, thank you, attorney. All right, Attorney Vazina, you had your hand raised.
Yeah, I just, I thought we were here to argue about the proposed decision, not things that were not in the proposed decision. So I started to hear things that were not addressed by the hearing officer.
Okay.
Procedural, I'm not going to dispute. I mean, the hearing officer notes that that the department did not provide expert testimony on things such as institutional equivalency and the transcript evaluation. I can't dispute that, but now I'm hearing today that there's an argument that, you know, the board also would have to give proper notice if it was going to be using its expertise. So I'll defer to the board on that, and you know, Attorney Bannon, you know, giving advice to the board on any of those issues.
Okay, thank you, Attorney Vazina. So Attorney Bannon, you know, well, I've got Cindy's hands raised. We have a motion on the floor, right? We already have a denial of this proposed memorandum of decision that we were in the discussion period, and then we listened to the oral argument of the attorney. So let me just take the hand raising of Cindy. Cindy's going to speak for a moment, and then at that point in time, I will ask Attorney Bannon if we need to do anything else, just to make sure I'm doing everything legal here. And then we will go with the motion.
If I may, Madam Chair.
Yes.
My recommendation at this point is actually going to be to suggest to the board that you table this and request briefs from the parties.
Okay.
I think that there were a lot of legal issues that particularly, I don't want to mispronounce your last name, sir. Attorney Menschel?
Yes, you got it
Yes,
right.
Attorney Menschel
One of the
raised.
few. Yeah.
I'm sorry?
One of the few people who pronounced it correctly.
Thank you. So, you know, I think that there were a lot of legal arguments that particularly Attorney Menschel raised. And I think that it would be helpful to the board and the attorneys advising the board to have the parties brief some of those issues. And what I've heard, particularly, I know there was, and I think promissory estoppel was something that wasn't necessarily applicable to this proposed decision, and the parties, and I'm deferring to the board with this, can brief whatever issues they want, but specifically what I would recommend the board request briefed are, you know, procedures with respect to denying this proposed decision. Specifically, I heard Attorney Menschel indicate, you know, case law with respect to the board relying on its own expertise and notice issues.
Okay. All right. So if we are going to go forward and table this, how do we make a motion to table?
It would be a motion to table. And at this point, you know, I know that, and first I want to thank both attorneys for, you know, their incredibly thorough oral argument. And what I like is for this to be, as I'm assuming the parties would like as well, for this to be resolved as expeditiously as possible. I don't know, I know the board's next meeting is on June 17th. I don't know if that's enough time for the parties to be able to submit briefs prior to that date. Alternatively, I believe the board isn't meeting again until July 15th. So I would, you know, on behalf of you, Madam Chair, if it's okay, I would defer to the parties for the timeline for that.
Sure.
But I would just recommend that the briefs be submitted at least 3 days prior to argument on to kind of taking this off the table.
Okay. All right. All right.
Does that make
so-
sense? I can
Yes.
restate if necessary.
Yes, that makes sense. All right, so one of the board members, we would need a motion to table this, this proposed memorandum of decision so that we can get information, briefs with regard to procedures, case law, notice, etc. Okay, and that we would get all this information at least 3 days before when we're going to hear it, our board meeting. We're not sure when that is going to be, but at least 3 days before. So if you could
So
put
why
that.
don't we do that, Madam Chair? I'm going to suggest that. Is the 17th enough time, or would the parties prefer July 15th?
Are you talking about simultaneous briefs?
Yes.
Okay. Well, 3 days before is this Sunday, the 14th.
Right. So I would say either June 12th, if we're looking at the June 17th meeting, or July 10th, if we're looking at the July 15th meeting.
Well, I can do it by the 12th. He'd be.
Attorney Fazina?
Well, I would prefer the July meeting, but I will endeavor, if that's not agreeable, I will endeavor to, you said June 10th?
June 12th
Oh,
will be
12th.
the date briefs are due, and then we can schedule this for the 17th. And Ms. Karpuska, I apologize for leaving you out of the scheduling of this. I assume it's okay, but perhaps I shouldn't assume that there's room on the calendar for this, for the 17th.
I know that I'm just going to throw this out there. I know that we have some fact finding from another case on the 17th, correct, Brett? We have
We
fact
do, but
finding.
would this be part of the board meeting?
Yes.
Yes, so
Okay.
currently I don't believe I have any items for that agenda yet.
Okay.
Great.
I just want to make sure.
Okay. So, Chairwoman Reiners, what I would recommend is, you order the briefing, that briefs be due June 12th, and then my advice would be to vote on tabling this matter until the board's next meeting on June 17th.
Okay. All right. All right. So can I have a motion from a board member with regard to tabling this agenda item that we're speaking about?
This is Cindy. I'll make a motion to table the case of Rochelle George RN APRN petition number 2025-299 and 2025-298 to the June 17th board meeting.
Okay. All right. May I have a second?
I second that, Diane.
Okay. Diane, thank you. All right. We have a first and second. Questions, concerns? For board members only. Okay. Not hearing any, so I'm going to take a roll call. Bear with me for a moment. I grab that sheet. Please mute yourself. Anyone that's speaking, please mute yourself. It's very distracting. Thank you. Okay, thank you. Brett, if you can mute people, that would be great. It would be really helpful. Okay, Cindy?
Aye.
All right, Sal?
Aye.
All right, Camille?
Aye.
All right, Lisa?
Aye.
Okay, thank you. Diane?
Aye.
And I, Gina Reiner, say aye. All right, so this has been tabled. All right. And do I need to say anything else, Attorney Bannon, with regard to the date that we just talked about, or are we set?
No, you should be all set. And I just want to say thank you to the parties and to the board.
Okay,
I have a question for Attorney Bannon.
right ahead.
Hi, Attorney
Sam.
Bannon. So can you clarify for me, I'm trying to understand this, that I guess maybe I misunderstand that we can't use our expertise to come up with our
Sal, that's one of the things that's going to be briefed. There is a
Okay.
statute that allows the boards to rely on their own expertise, but the issue that's being raised by Attorney Menschel, and I hope that he will correct me if I am misconstruing what he was arguing, is the notice issue, whether you're required to notice that you intend to rely on your expertise.
Thank you.
Attorney Menschel, you're muted.
Sorry, I would just supplement that with, it's not only the notice that you're going to, it's the facts or and it'll all be in the brief, but the facts that you're relying on to give us an opportunity to respond at a meaningful time. So, yeah, that'll all be in the brief, but yes, that's correct.
Thank you.
Okay, thank you. Okay, we will continue on to the pre-hearing review. We'll do that, and I don't believe there's a hearing after this. I just want to make sure our timing, okay, for today. I don't believe there's a hearing after this, but maybe at that point, after we do the pre-hearing review, we will take a break, for a 15-minute break, so people could bathroom, what have you, whatever. All right, so we will do number 6, take a break, and then we'll go into school business. But Brett, let me know if there's a hearing. It's escaping me. I should have the panel hearing tracker, but I don't have it up. Okay. All right. So let's continue. Juris Marie G. Polonga, RN petition number 2022-773. This is with Attorney Vazina. Okay. And I see her there. Attorney Vazina. Thank you. And let me just ask, so again, pre-hearing reviews, we, are not making any, obviously there's no votes. It's a pre-hearing review. We're reviewing the information we received. I have it right in front of me, in our secure site. And there is a respondents counsel, Michael, I believe it's Kurz, K-U-R-S. Is Michael here? Attorney Kurz, pardon me. Okay, I
Yes.
see him. Okay, very good. Thank you, Attorney Kurz. All
Thank
right,
you.
and great. All right, so I just want to make sure all board members receive this information. And what we'll do is, and Attorney Bannon, let me know which way you want to go with this, if we're not doing this appropriately so. Is that perhaps Attorney Vazina can give us a small synopsis on this pre-hearing review. I have the paper in front of us. All of us would have read this, but if you could give us a bit of synopsis, that would be great, and then we can go forward. And again, this is a pre-hearing review. We're not voting on anything, my understanding.
So my understanding is that the pre-hearing reviews are done on the papers. So I'm not, and
okay.
they're
okay.
yeah.
Okay, very good. All right. So Attorney Bannon, are you there? So it's been I do want to apologize to the board. There's been a lot of changes in our procedures. I've been on the board a long time, but just want to make sure I'm on top of it all. So,
Madam
Hi, this
Chair.
is Attorney Baum. I'm just going to fill in for Attorney Bannon for a moment.
Sure.
The pre-hearing reviews can absolutely be done on the papers. There's nothing prohibiting it. If you'd like it to be done some other way, that's within your prerogative, but typically they are done on the papers.
Okay, and so my understanding is that, obviously we have the information, we're looking it over, we're talking about if we are going to go to hearing and what the board would, or, what the board would be considering for the situation that we're reading about, So let me just ask you, Attorney Baum, are we just opening this up for discussion at this point between the board members?
That's correct, yeah.
Yes, that's how I knew it before. I didn't know if anything changed. All right, Attorney Vazina.
Yeah, if I may, I mean, the board, the parties are coming to ask the board to provide a recommendation. So in the past, I believe that's included perhaps consent order terms that the parties would then negotiate and come back to you with.
Okay, yeah, so it's basically the same. I think I've been on the board like 14 years or whatever. Okay, so nothing's changed there. Good. Just want to keep myself up to date. All right, so board members, we've got this information. We're going to make recommendation, with to Attorney Fazina, the attorneys, the two attorneys that are here. And having read this, the other attorneys, Attorney Kurz, and then they go back and they work out consent orders, what have you, and go from there. So we would open this up to discussion to board members only at this point and see what people have to say. All right, so if any board member wants to make a comment, discussion, this is, if I may, we won't get into too much in a sense, obviously being careful of any private information, but this is a DOC situation where this nurse was practicing, okay, in the Department of Corrections. We do have an investigative report. We have a complaint from a chief operating officer at the DOC that we always received, personnel file, investigation record, so forth. So any thoughts on this, board members? Give you opportunity to share with regard to what was happening in this case. Sorry for my being so verbose, but I just want to make sure everybody's on board. Yes, I'm sorry, Cindy. I was just
Yeah, I'll start the conversation.
Yes.
These are they're very serious allegations, very serious lack of failure to rescue, failure to provide adequate care. I would not be opposed to revocation as the remedy for this. If not that, then some serious re-education. I would say a civil penalty. I would say reprimand for sure. This needs to stay on this nurse's license. But I do think it reaches the level of potential revocation personally.
With Gina Reiner speaking, I see it as very serious, as my colleague just said, and board member. If, obviously my concern is that it's so serious that if it needed to come to a hearing, so that we actually get, a hearing where we can ask some questions and so forth. We do have the documentation, but if needed, I would not be opposed to actually having a hearing being conducted with regard to this. But yeah, I mean, I would definitely agree with a reprimand, a monetary penalty, and definitely education, no doubt, education. But this is very involved and complicated. Go ahead, Cindy.
I'd just like to add that if it does go to a hearing, which I think was probably a good idea, that I'd like it to be before a panel, not just a hearing officer.
Yes, I concur. Thank you for bringing that up. I should have said that. I concur with you that I definitely go to a panel of our board, Any other board members that want to give more recommendation to the attorneys that are involved, the respondent's attorney and the DPH attorney? Yes, Lisa.
Yeah, I was just going to say that because of the seriousness of everything, I think that a hearing would be desirable so that we can not just, say what we want, but also so it will be backed up by evidence and what we're basing our decisions on, because it is serious and it needs to stand. That's it.
Okay, thank you. Thank you. Any other board members that would like to make any comments, contribute to recommendations? reminding board members that there's, obviously probation. And with regard to probation, obviously it could be so much time. I'm making up time right now. I'm not saying for this case, but just to give, that we have a few new board members. So I just want to make sure the new board members are aware. All right, just kind of throwing that in. Sal, you have your hand raised.
Yeah, I just want to make a comment that I do think this needs to go to a hearing, and I could not make a recommendation based on just reading it, because when I'm reading it, I do question some stuff in there. So again, my recommendation would be a hearing and for it to be heard.
All right. Judy, and again, I concur with the hearing myself. But do you have enough information? Both attorneys, feel free to respond to my question. Do you have it? My sense is that the board members are looking towards our hearing, so we can go through that procedure, hear both sides, so to speak, hear arguments, hear evidence, so forth. Attorney Pazina, do you? Yes, attorney. Whatever your hand
Thank you.
raised there.
Someday I'll
Yes.
get a hang of the electronic raise the hand, but
that's fine.
The actual hand sometimes works for me too. Just to point out, since this all began, I've been made aware, in fact, in the last month, that the Department of Corrections and my client have been sued related to the matters that are the subject of what's been presented to you. The state hasn't, to my knowledge, made a decision about whether it's going to represent my client as a former employee of the Department of Corrections. And I would be at least hesitant to have a hearing before the state decides how to proceed in the personal injury case. Plus, the state might wish to not have a hearing while it's subject to potential liability for the lawsuit. So I just wanted to raise that. My client is open to resolutions that take into account that this was a bad situation that she was in. Nobody's looking to make excuses. An unfortunate aspect of it is she hadn't been trained in the emergency procedures. The jail did not have codes. The jail did not have walkie-talkies. And, on top of everything else, in the record, the state police investigator concluded that the inmate had been dead for a number of hours. So I just want to make mention
sorry
of that.
to interrupt, but we're
That's
not.
right. Go ahead. Go ahead, Attorney Fazina. Go ahead.
Yeah, I'm sorry to interrupt. We're not. I thought this was done it was being done on the papers, and what I'm hearing today from the board members is that they prefer that a hearing be scheduled. So the only question I had, I think there was a mention of re-education by a few members, but I don't know if there's any particular if anyone has any specifics on what that might be. I believe that the packet that you considered had she's already taken some re-education with I believe the American Heart Association.
Well, with regard to education, obviously emergency services, emergency protocols, that's what I can think of. Cindy, you have your hand raised. Want to add to that or anything?
I would add, something on regarding duty to act, your responsibility as a
Yeah,
nurse to
yeah.
respond,
Mm-hmm.
and then personal responsibility to know the emergency procedures, to know what you're supposed to do. That's on you to find out.
Mm-hmm. Yeah. Someone brought up civil penalty, monetary penalty, I think it was, if I get that right. I don't know who brought that up, but I think it was Cindy, I'm not sure at this point, I'll be honest with you. So if there was a monetary penalty, does anybody want to talk about that, just to give information for the attorneys, for Attorney Fazina? Again, we're strongly asking for a hearing, but
Right.
you know,
I think
maybe
a hearing is definitely warranted.
warranted.
I said the monetary fine. I never know what to say for that. I mean, I don't want to completely destroy a person, but we want to send a message that this is absolutely unacceptable behavior of a nurse.
Yeah.
So maybe just keeping that in mind.
Okay. All right. Okay. Do you have enough now at this point?
The information I have is appreciated. Thank you.
Okay. Very
Yes,
good.
we appreciate your review. Thank you.
Okay. Very good. Excellent. All right. So we are going to take it's 11:06. We're going to take a 15-minute break. So, well, let's do it this way. It's 11:06. And my computer is off. Let me make sure that I got the right time for you all. Okay. All right. So let's, why don't we come back at 11:25? People can just take a moment and stretch or whatever. 11:25, return everybody. Okay.